G'day, it's Phil Anderson, General Manager, Policy, Advocacy and Standards at the FAAA. Thanks for joining me for another video in this series of guidance on the new DBFO reforms. In this video, we're going to focus on ongoing fee arrangements and client consent. I'll provide you with more detailed information about the new client consent requirements for ongoing fee arrangements and the deduction of ongoing advice fees from a financial product. This part of the DBFO bill implements important elements of Recommendation 8 of the Quality of Advice Review and aims to consolidate and streamline the consent process for advisors and clients. These DBFO amendments introduce a number of changes to the client consent requirements. My aim is to explain each of the separate changes, how they interact with each other, and the transition arrangements that you should be aware of. The current client consent requirements for the deduction of ongoing fees from a product are contained within an ASIC determination. The DBFO bill has now codified these requirements in the primary legislation. ASIC's guidance on ongoing fee arrangements, which is Information Sheet 256, will continue to apply until these changes commence. And ASIC has said that they will release new guidance before the 10 January 2025 start date for these changes. We hope that this video helps you understand your new obligations, particularly the requirements you need to consider when consolidating consent forms. As you know, ongoing fee arrangements are for personal advice provided to a retail client where a fee is to be paid during a period of more than 12 months. A fee arrangement for 12 months or less is not classified as an ongoing fee arrangement. The first change relates to the content of the client consent form, and it must include an explanation of why you are seeking your client's consent, the maximum period before the consent ceases to have effect, the services that your client will be entitled to receive during the coming 12 months, the amount or an estimate of each ongoing fee, and the frequency of the ongoing fees. This means the look-forward information currently provided in your FDS will still need to be provided in your client consent form. And for joint accounts, the consent of all account holders is required. There is some additional information that must be included in consent forms for deducting ongoing fees from your client's product. The consent must specify the name of the account holder and the account number, the amount or reasonable estimate of the amount to be deducted, and the consent must be signed by the account holder and include the date of consent. You must make sure you include this information in the written client consent form for fee deductions that are entered into or renewed after 10 January 2025, or the arrangement will technically be considered terminated. The amendments clarify the variation rules for client consents. A change to the services to be provided under an existing ongoing fee arrangement would require a variation of the consent or a new consent. However, a change to yours or your client's name or contact details, for example, if you change your surname by marriage, would not trigger the need to vary the consent or seek a new consent. However, the explanatory memorandum to the bill states that it would be best practice to notify your client of any changes to your name or contact details as a courtesy. The changes to the legislation gives the Minister the power to approve standardised consent forms for entering into and renewing an ongoing fee arrangement, as well as for deducting and arranging to deduct ongoing fees from an account. While the Minister does not have to approve a form or forms for all circumstances, we're actively encouraging the Minister to approve consent forms so the critical efficiency gains of these changes for advisors and clients can be realised. If the Minister does approve one or more consent forms, it is mandatory for these forms to be used. The explanatory memorandum to the bill makes it clear that any approved forms can be relied on by both advisors and product issuers as evidence of a client's consent. This is an important statement to ensure product providers are clear that the approved client consent form can be and should be relied upon for the deduction of advice fees. However, product providers may request additional information before deducting ongoing fees from an account and may decide not to allow deduction of fees from the account. For example, if the deductions are inconsistent with product rules or in breach of the sole purpose test. At this stage, the Minister has not approved a form. However, we hope that this will happen in good time. If you're required to give multiple consent forms to your client, the DBFO reforms permit you to combine the information you must give your client into a single consent form. However, there are certain aspects you need to consider when consolidating consent forms, including the information you must include, the appropriate date for the consent, and your privacy obligations. So yes, you can consolidate client consents, for example for ongoing fees which are deducted from multiple accounts, including across multiple account providers or product issuers, into one consent form. To create a consolidated consent form, you must make sure the single consent form includes all the information that is required for each of the individual accounts. It must also clearly state why the form is being given. This means it must state the purpose of each consent the client is agreeing to. Given the consent includes client information, you must consider your privacy obligations when passing on confidential information in the single consent to different product providers. You can also consolidate Minister-approved forms when available. However, the consolidated form must be consistent with each of the individual approved forms. These changes also allow you to consolidate notices, such as a confirmation of a variation, into a single notice. In addition to ensuring the information and purpose of each notice is included, you must also make sure the single consolidated notice is provided on a date that satisfies the requirements of each individual notice. For example, if you provide a written notice to a client that an ongoing fee arrangement and the authority for the deduction of ongoing fees is terminated, you need to ensure the single notice is provided within 10 business days of each of these events. As with the current requirements, you must give a copy of your client's consent to deduct advice fees to the account provider. And if your client does not renew your ongoing fee arrangement or the arrangement terminates, you must give the product provider written notice of this outcome within 10 business days. There are a few important changes to when you can renew your client's consent for your ongoing fee arrangement and the deduction of ongoing fees, all of which commences on 10 January 2025. They have introduced the ability for you and your client to agree on a new day to renew your agreement, known as the reference day. And they have extended the time frame for the renewal to 60 days before the anniversary and 150 days afterwards. At present, the renewal period is based around the anniversary of the day the client consent was previously given, and it wasn't possible to change this. Under the DBFO reforms, you and your client will be able to reset the anniversary of your agreement by agreeing on a new day. This is called the reference day. Once established, the reference day will be the new day that determines when your renewal period commences and ends for your client to give a written consent to renew your ongoing fee arrangement and fee deductions. There are a few important steps you need to follow to put in place a new reference day. Most importantly, you and your client must agree to changing the anniversary day for your agreement to a new date, the reference day. The new reference date must be included in your previous client consent. In your client consent, you must include the duration of the client consent, or when the client consent terminates. This should be either the anniversary of the arrangement, or if you and your client agree to bring the renewal forward, the reference day. And the reference day must be a date that is earlier than the anniversary of the day that the ongoing fee arrangement was entered into. If a reference day is agreed upon, this will become the new anniversary of the arrangement going forward, unless you agree to change it again. You can reset a new reference day whenever your client renews your agreement. It just has to be agreed to in advance. Next, the DBFO reforms extend the renewal period. The new renewal period aims to give you more flexibility by extending the window of time during which the client consent can be renewed. From the start day, being 10 January 2025, you will have 150 days after the anniversary day or the reference day to renew the client consent. This combines the current 120-day renewal period and the 30-day termination deadline if your client doesn't respond. Under the new 150-day renew period, there will be no additional 30-day period. If your client does not give you a new consent for your ongoing fee arrangement and for the deduction of ongoing fees, the arrangement terminates at the end of 150 days. So in summary, these changes mean that each year a written consent that contains all the required information must be given by your client in the time frame that starts 60 days before and ends 150 days after the agreed reference day that is stated in your previous consent, or the anniversary of either your previous reference day or the anniversary of the day on which the arrangement was entered into. If this does not happen, the arrangement terminates at the end of 150 days. There are transition arrangements that apply to all these changes, which I'll explain later in this video. As is the case both now and under these changes, your client can withdraw or vary their consent at any time. This must be done in writing. So your client consent for your ongoing fee arrangement and the deduction of ongoing fees terminates immediately if it is not compliant with the current or new consent requirements, such as the content of the consent doesn't meet the requirements. Your client does not renew their consent in writing within the permitted time frame, or your client withdraws or varies their consent. When a client withdraws or varies a consent in writing, you must give written notice to your client within 10 business days to confirm that the notice was received. If you are deducting ongoing fees from a product provider under the ongoing fee arrangement, you must also notify the product provider in writing that the client consent for the deduction of fees was withdrawn or varied and within 10 business days. There are important transitional arrangements you need to be aware of in relation to the new client consent obligations. As with some past changes in the advice legislation, the transitional arrangements include the terms start day and transition day. The transition arrangements do not start until 10 January 2025. This is called the start day. So at a minimum, you must continue to comply with the current client consent requirements until at least 10 January 2025, when the transition arrangements commence. After the start day, the changes apply in different ways to new and existing ongoing fee arrangements. Where a new ongoing fee arrangement is entered into on or after the start date, that is 10 January 2025, the amendments automatically apply to those new arrangements. This means you must ensure the client consent form for these new arrangements meets the new requirements and contains all the required information. Transition day is the first anniversary of the day an existing ongoing fee arrangement was entered into that occurs on or after the start date. So the new client consent requirements apply to existing ongoing fee arrangements at the first anniversary of the arrangement that occurs on or after 10 January 2025. These transition arrangements also mean that you cannot set a reference day until after 10 January 2025, as this is the start day for these changes. As the reference day must be set and agreed to in the previous client consent, the first opportunity you can do this will be the first renewal after 10 January 2025 with effect from the second renewal. Now let me use an example. Existing ongoing fee arrangement anniversary of 15 December 2024. We understand that these transition arrangements are causing some confusion and thus the best way to demonstrate this to you in terms of transition arrangements is to use an example. If you have a client with an existing ongoing fee arrangement that has an anniversary day of 15 December 2024, you must continue to meet the current client consent obligations, as this is prior to the 10 January 2025 start date. The current client consent requirements will apply to the renewal of this arrangement, so the client must provide consent to the renewal of the arrangement on or before the end of the 120-day renewal period, which ends on 14 April 2025. The current client consent obligations continue to apply even though the renewal period does not end until after the 10 January start date. So you cannot consolidate your client consent forms for this renewal, and you cannot set a reference day in this client renewal. The first anniversary of this ongoing fee arrangement occurring after the start date is 15 December 2025. So from 60 days before this anniversary, being 16 October 2025, you would be able to put in place a new client consent. This client consent must include the look-forward information about your fees and services. You are permitted to consolidate your client consent forms into a single compliant form for this renewal. And you can agree with your client to bring forward your next anniversary day by including a reference day in this client renewal. 150 days after the anniversary is 14 May 2026, so a new client consent with the looking forward information must be agreed to by then, or the arrangement will terminate. You must continue to keep records in relation to client consent requirements for ongoing fee arrangements and deducting ongoing fees from your client's product. The penalty for failing to keep these records is up to 5 years imprisonment for individuals, which is certainly a good incentive to get this right. Now, in conclusion, there are also changes to the client consent requirement for non-ongoing fee arrangements, particularly in relation to deducting fees from the client's superannuation account. I will address these changes in my next video. Thank you for listening today.